सुधार के बारे में काफी अच्छा है। प्रखर लगता है आप सनातन के अच्छी तरीके से बात करते हैं, आप अच्छी तरीके से बात करते हैं, आप अच्छे फॉलोअर्स हैं।
ಗೊತ್ತಿಲ್ಲಾಗಿದೆ
VC ಅವೇನು
ಫ್ಲಕ್ಚುಯೇಟ್ ಐತಿ ಹೋಗೋದು ಬರೋದು ಏನು ನೆಟ್ವರ್ಕ್ ಇಶ್ಯೂನಾ ಏನೋ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ.
ನೆಟ್ವರ್ಕ್ ಸ್ವಲ್ಪ ಇಶ್ಯೂ ಇದೆ.
ಮುಂಜಾನೆ ಒಂದು ಬಿಸಿ ನಮ್ದು ಇರ್ತಾರ ಪಾಪ, ಆಮೇಲೆ ಬರ್ತಾನೆ ಇಲ್ಲ ಅವ್ರು. ಆಫ್ ಮಾಡ್ಲಾ?
judgment, Lord. It is what my lords have held up in the writ appeal confirmed. And Lord, the thing is, uh, here, my Lord, the negligence what we have challenged, for that we, in fact, while preparing the appeal and filing before this honorable court, highlighted that point. Evidence is required for that. He sustained electrocuted injury immediately. And my Lord, 80% of the my Lord, disability was found with and sought for the whatever the compensation amount against the JESCAM. And later on, he files in 2013 or 14 before the Consumer Forum application, a petition before. And the said petition came to be withdrawn, dismissed or withdrawn. Dismissed as withdrawn, challenging before the proper forum. And later on, this writ petition is filed, And my grievance is, say, without looking into.
Electrical inspector has given a report, is it?
In this case, there is no such electric inspector report also.
Otherwise, charge sheet, FIR.
Only the complaint was given, it appears.
To the Power Transmission Corporation.
Power, the other side. In 2013, it is alleged in the writ petition, while statement of objections on behalf of JESCAM, that the notice was given to these residents who are all situated under the high tension wire to vacate as early as possible. But they did not do so. And this is a one minor child who, to catch the pigeon on the roof of somebody's house, he came in contact with high live tension wire, and accordingly sustained. That's how the alleged injury. And
no, but any dispute regarding the occurrence of the accident?
There is no
dispute regarding the occurrence of the accident.
Occurrence of accident, my lord. We are totally not denying, my lord. In fact, our main grievance is it was, my lord.
Did you file your objections before the single judge?
No, we have not filed. Only the matter was defended and thereafter disposed of. Here we, my lord, filed those details of the District Consumer Forum, where other side.
Filed your objection, is it?
Objections here, he has not filed.
The appeal is by? Appeal is by?
Appeal is by JESCAM. And contempt petition is by other side.
Correct. So what is
for not?
What is the stand that you have taken in the appeal?
Lord, kindly see mine annexure.
Now, regarding the accident, is there any material that you went and inspected the place, electrical inspector's report? Ariti enu ilva?
Ariti, there is no such inspection report. No. Kindly see page 53, annexure D. And supported by.
Now, this is a complaint by?
Complaint by the family, that is a minor child who injured, father of the injured person.
We'll have it tomorrow. There's some dictation, we'll have it tomorrow. No, but you tell us now, is there any evidence to indicate this accident happened because of touching of high tension?
My main focus is on negligence and carelessness on other side also. As because kindly see page 15 and annexure G to the writ petition.
59.
59. Legal notice issued, my lord. And later that is by the advocate for the claimant injured, 23/9/2013. For that, we, my lord, in 62, page number 62, annexure G1, the reply to the said legal notice. May
You
I,
have
my
made
lord,
out a reply.
please. 26/9/2013 ನಿಮ್ಮ ಲೀಗಲ್ ನೋಟಿಸ್ಗೆ ವಿವರಣೆ ನೀಡುತ್ತಿರುವ ಬಗ್ಗೆ ಈ ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಮತ್ತು ಉಲ್ಲೇಖದಲ್ಲಿರುವ ಪತ್ರ ಸಂಖ್ಯೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ತಮ್ಮ ಮಾಹಿತಿಗೆ ತಿಳಿಸುವುದೇನೆಂದರೆ
Will pass over. There one dictation is there.
published.
In this matter, my lords, the only consideration is before that 1 year, my lords, all the villagers have made a complaint to remove the high tension
See,
wire.
no done. But accident is not in dispute.
Not in dispute, and FIR is registered,
Huh.
and FIR is also produced along with the petition. my lord.
In their appeal memo, they don't dispute the accident.
No, no. There,
See,
in respect of the my lords, incident concerned, there is no dispute.
No dispute. Only regarding the
Whether he is negligent, that is what they took up the.
Partially we, my lord, disputing in the sense that whatever the injuries he is telling, once the person, whoever comes in contact with high live tension wire, my lord, there is a 99% possibility of death only. There is no chance of lord, like injuries, whatever manner they are, my lord, putting up before the court, and that's what.
But now the certificate says only burns.
Certificate, it is by the, that's how, my lord. We thought of cross-checking all those things. Otherwise, we will not be having any opportunity to cross-check or cross evidence. And straight away, my lord, this is how the huge compensation is burdened on JESCAM. And on that hearing only, my lord, this honorable court pleased to grant us stay of the matter. And this
Since
is a point, my lord. These are the 2 points, my lord. Mainly, one is the injuries, whatever the manner they sustained, my lord, while coming in live contact wire, that to high tension wire. Possibility of amputation does not arise. That is one point. And the second point is the notice was already given to the all residents where they situated below that high tension wire in 2013 itself. Even in spite of that, they did not vacate the place and continued residing. And in between, this incident happens.
Correct. You must, I think we have said in that judgment that you must go ahead and demolish whatever in your power.
That is what observed.
Pass over.
Out.
Published.
Unless you have to see if there's any doubt regarding appeal. They will permit ಅಂತ ಏನಂತ ಮಾಡಿದ್ದೀವಿ ಅವ್ರಿಗೆ in case they say we should get it yes.
May I make one mention? Serial number 51. Parties have come, my lord. It is I mentioned and moved the matter, stating that matter is settled.
Settlement.
Yes.
Huh?
Yes, settled. Yes.
Settlement.
Yes.
Idara?
51. Yes. 4:30 or 4 o'clock. Please.
What RFA or what?
MFA, my lord, challenging decree of divorce, not dismissal of dissolution.
Password. Dictation. We'll take up other matters after the dictation.
Serial number 50, Mahantesh Desai.
My lord, this is victim appeal. Victim appeal, my lord. My lord, here the victim has examined PW1. He has supported the case of prosecution. And medical evidence is also corroborate the version of the prosecution. Yelli contradiction omissions yavadu tarlilla sir avaru. And but except this accused number 1 another split up and 2 and 3 ಗೆ ಅವರು ಇದು ಮಾಡಿದ್ರು. As per the case of the prosecution, vote act of this accused number 2 and 3, A1 assaulted with rod on the head of the PW complainant. A2 assaulted with stick on the back side, chest side and left hand and thigh. A3 assaulted with hands on the cheek, my lord. My lord, here no finding is given regarding the 34 of the IPC, common intention. Because
para 32 of the judgment.
Yes, my lord.
There is no such intention, and medical evidence also in respect
That shows
to
the
weapons
grievous
and other
grievous injury ಅಂತ ಹೇಳ್ತಾರೆ sir. Medical opinion also shows that grievous injury. And here
There is a civil dispute, alva?
civil dispute ಇದೆ sir. Eyewitness ಇದ್ದಲ್ಲಿ motive is not plays important. Because he is the injured person, he has seen the incident. To discard him,
Has not preferred any appeal?
No.
State has not.
No,
preferred.
no.
Him appeals against acquittal. Yes, what is it?
ಅಲ್ಲ, at least 324 ಅರೆ ಮಾಡಿ ಅವರಿಗೆ ಫೈನ್ ಬಿಕಾಸ್ ದೇರ್ ಇಸ್ ಎವಿಡೆನ್ಸ್ ಮೇಲೆ. ಅದರ್ವೈಸ್ ನಾನು ಇದು ಐ ವಿಟ್ನೆಸ್ ಸಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಕನ್ಸಿಸ್ಟೆನ್ಸ್ಲಿ ಎಲ್ಲಿ ಹೊಡೆದಿದ್ದಾರೆ ಹೇಳಿದ್ದಾರೆ ಸರ್. ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಕೊರೊಬರೇಟ್ ಇದೆ ಸರ್. ಅವ್ರದ್ದು ಓನ್ಲಿ ರೀಸನಿಂಗ್ ಏನಂತಂದ್ರೆ ಇನ್ ಪ್ಯಾರಾ ನಂಬರ್ ಜಜ್ಮೆಂಟ್.
As per the accused number 3 is an engineering student, according to you.
That's true, my lord.
Not there.
But caste
That
title
shows.
my lord, caste title show that he is a businessman. Caste title show that
In your cross-examination.
I am admitted, my lord. His injury is only he fisted antide sir. ಕೈಲಿ ಹೊಡೆದ ಅಂತಿದೆ. But to discard allಕ್ಕೆ ಅವ್ರು ಏನು ಕೇಳೇ ಇಲ್ಲ sir.
Well, that itself shows.
But,
Where in complaint it is stated that he has assaulted.
Assault.
But in evidence he states that he was an engineering student, he was present, that's it. Uncle assaulted. with
And
the
moreover,
rock.
my lord, even after assaulting him, he tried to escape from the place. They followed him and assaulted. So 34 is applicable ant. Only
That's
302
the complainant's appeal. Is the against
at least
acquittal.
324 ಮಾಡಿ he has spent more than 1 lakh expenses for medical expenses. On fine impose ಮಾಡಿ ಕೊಟ್ಟರು ನಡೀತು. Consistency evidence sir. ಇಲ್ಲಕ್ಕಿದ್ರೆ ನಾನು ಕೇಳ್ತಿದ್ದಿಲ್ಲ.
Where is the
Eye witness is supported sir.
who's on other side?
PW1 and I.
Ashok Mulige.
Ashok Mulagi. ಕರೀದೇವ್ರು ನೋಡು.
ಅಶೋಕ್ ಮೂಲ್ಗೆ
ಕರೀದೇವ್ರು ಮಧ್ಯಾಹ್ನ ಪಾಸ್ ಓವರ್ ಮಾಡಿ. ಇಲ್ಲಿ ಪಾಸ್ ಇದು ಕೊಡಿ.
number 56.
Then session judge, while acquitting the accused, comma, in the judgment, acquitting the accused in the judgment, comma, in paragraph number 16, 16, 16, comma, stated, narrated the reasons as under paragraph number 16 and reproduce markoli. 16 as under full stop. We have on perusal of further on perusal of the further on reappreciation of the entire evidence on record, comma, there is no such compelling reason to interfere in the impugned judgment. Full stop. This appeal, nevertheless, this appeal is against the acquittal judgment. Against the acquittal judgment, comma, the Honorable Apex Court in the case of H.R. Sundar and others versus State of Karnataka, reported in 2023, Volume 9, SEC 581, summarized the principles to exercise the power by the appellate court to interfere in the order of in the acquittal order in paragraph number 9 as under. Next, the Honorable Apex Court also in the case of Mallappa and others versus State of Karnataka, reported in 2024, Volume 3, SEC 544, held that in a case of appeal against acquittal, comma, the appellate court must be slow in interfering in the impugned while reversing the said order. Paragraph number 42 held as under. As under. Hence, on careful perusal of the above law laid down by the Honorable Apex Court and also by on reappreciation of the entire evidence available on record, comma, except the uncorroborated version of PW3, the complainant, comma, the other material witness also turned hostile, and the prosecution has failed to place any such cogent materials to prove that the accused has posted the obscene messages and photographs of the victim in the social media, comma, we find there is no reason to interfere in the acquittal judgment passed by the trial court. Full stop. In that view of the matter, comma, we answer the point raised above in the affirmative, and proceed to pass the following order. The criminal appeal is dismissed, being devoid of merits.
अच्छा
ಅವ್ರು ಬಂದ್ರ ಮುಳುಗಿ ಬಂದ್ರೆ ಅವರನ್ನು ಮುಳುಗಿ ಅವ್ರನ್ನ ಕರಿ, ಯಾರು ಅವರು 2 ನಿಮಿಷ ಇರಿ, ಅವ್ರು ಬರ್ಲಿ, ಮುಳುಗಿ ಅವ್ರು ಬರ್ಲಿ, ವಿಲ್ ಟೇಕ್. ಮಾತಾಡಿ ಸರ್, ಸ್ಥಾನ ಅಥವಾ ಗೌರ್ಮೆಂಟ್ ಕೇಳಲಿಕ್ಕೆ 2 ನಿಮಿಷ ಕೇಳಿಬಿಡೋಣ ಸರ್, ಏನಿಲ್ಲ ಅದು ಕೂಡ ಮುಗಿಸ್ಕೊಂತ.
Number 57, Syed Mastan.
Yes, yes, 50.
yes
ಏನಿಲ್ಲ, ಅದು ನೋಡಿ, ಅದು accused number 2
yes sir.
is a specific case of the prosecution that accused number 2 only assaulted the deceased. The single blow. He inflicted a single blow on his head.
Yes.
So A2 is in custody from last 10, almost 11 years, 10 years, 6 months. As well, the accused number 1 and 3, the case that they assaulted PW 1 and 2
Oh,
and caused some simple injuries. It's only abrasions, swelling and abrasions. Accused number 1 and 3
Yes.
with the sticks. A2 with the axe on the head of a single blow on the head of deceased.
then it may come under,
Circumstance
it's not for part 1.
as far the A2 is concerned.
Yes, madam.
A1 and 3, at the most it may attract section 323. So charge also there for 323. 323.
Yes, madam.
They are on bail. 1 and 3 are on bail.
Yes.
A2 is in custody from last 10 years, 6 months.
Yes,
So the period undergone for A2,
yes.
304 part 1.
Once,
Huh?
if there is only single blow, madam, sit.
Single blow.
Yes.
Huh? So we'll proceed.
Please,
Huh?
please,
ಅಷ್ಟೇ ಇರೋದು ಬೇರೆ
please, madam.
Huh?
Please.
For dictating judgment. ನಾಳೆ tomorrow.
Please. Before dictating the judgment, I'll submit some.
Yes, yes, yes.
Please.
Yes.
Cell number 32. Ravi B. Patil.
He made the application for impleading the beneficiary as party.
Huh?
He made the application, my lord, beneficiary as the party in this contempt proceedings, but he is not party before the learned civil judge.
You are settling it amongst us.
ಆಗಿದೆ mediation ದಲ್ಲಿ ಆಗಿದೆ so that is already settled. But beneficiary is not before lordship.
ಅಲ್ಲ ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ ನಿಮ್ಮ ಮೀಡಿಯೇಷನ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ
ಹೌದು ಅವರೇ ಬಂದು beneficiary only appeared before the mediation mediator and also my lord, they agreed to pay that amount. But that has to be by of the sale deed. So that proposal, my lord, government has the, my lord, I'm instructed that that amount has to be released by the government. Then, my lord, get the sale deed directly from the complainant. That is the instruction. But beneficiary is, my lord, I informed to the beneficiary to present before lordship. But he is not turned up, my lord. Lordship, tomorrow, my lord, I'll try once again. Let him be lordship, before lordship, my lord. Then you lordship dispose of this content petition with my lord, presence of the beneficiary.
In terms of the mediation report, we take note of.
That's whatever it is that has
Last,
accepted also, my lord.
last date of hearing, my lord, the official had appeared before the court and took 4 weeks time to, my lord, resolve the issue. My lord, for preparing for execution of sale deeds. My lord, they have not even paid the requisite fees before the authority for the purpose of levying. We, in spite of, my lord, we approaching several times to the authority, they are not ready to do anything. No progress in the, my lord, matter. Last date of hearing 4 weeks time was sought for. ಅದಾದ್ಮೇಲೆ ಅವ್ರು ಏನೂ ಮಾಡಿಲ್ಲ. A nominal fees, my lord, to be paid by, my lord, the authority for the purpose of levying, that is also not done. If this contempt is closed, my lord.
The order sheet, sir, my lord.
ನಾಳೆ
Tomorrow only first matter, my lord, let it be, my lord. We will ask the officer to be present.
relist the matter in the orders list tomorrow.
Please.
Number 33, Abdul Muqtadir.
I'm appearing for defendant, my lords. There is a delay of 213 days, my lords.
Let notice go.
My lords, the delay is notice is served, my lords. My lords, the delay is because the RA was filed.
Let him come. We'll condone the delay and we'll consider your plea. You bring him and come.
Please, my lords.
Pass over.
Serial number 34, SS Mamadapur.
For the complainant, Lord's learned single judge, Lord's had passed Lord's positive direction against the fifth respondent therein. Lords may kindly peruse the operative portion of the order, page number 17. Writ petition is allowed in part. Fifth respondent is directed to issue survivorship certificate to the petitioner that she is the wife of the deceased Vittappa alias Vittal, subject to the result of civil suit pending between the petitioner and seventh respondent. Pursuant to this, I made an application before the fifth respondent herein. Again, citing the Lord's the civil dispute pending between the petitioner and the respondent number 7 once again has issued an endorsement rejecting my prayer. In fact, we have filed an affidavit before the learned single judge stating that except for the service benefits, will not take the benefit of the survivor's certificate for anything else. Recording that submission, this Lord's positive direction was passed against the fifth. Again, this annexure C, page number 21 is issued.
Now notice must go to. Notice must go to
Notice Lords to,
1.
yes, respondent number 1.
Issue notice to accused number 1. AGA GA accepts notice for respondent number 2.
Please.
Return relist on.
Please.
Number 35, Bavi Katti, Revan Siddha Vittal.
ಇದ್ರಾ ಇಲ್ವಾ ಫಸ್ಟ್ ಟೈಮ್ ಪಾಸ್ ಓವರ್ ಬಂದ್ರೆ ನೋಡೋಣ ಅಷ್ಟೇ ಪಾಸ್ ಓವರ್ ಆಮೇಲೆ ಡೇಟ್ ಕೊಡಿ ಅಷ್ಟೇ ಎಸ್
Serial number 36, Mahesh Patil.
In this matter, the government was asked to secure some instruction and records from the government.